Hi, I'm Sabine, the Purpose Lawyer. Thank you for listening. Please don't forget to like and subscribe to this podcast. It really goes a long way. It helps us spread the good word. And if you or anybody you know is in the market for legacy or estate planning or business or trademarks, please reach out to our firm. It's the Ambitious Legacy Firm. We are licensed in New York and New Jersey, but we have service partners in all states. So we'd love to work with you. Asset protection, legacy planning, trademarks. We got you. All right. So it's theambitiouslegacyfirm.com. Now let's get into the episode. Welcome to another episode of the Ambitious Legacy Podcast. I'm your host, Sabine, the Purpose Lawyer. Thank you for listening and thank you for helping me be on purpose. Thank you guys. Welcome back. Today I'm going to share a story about why the hell you need somebody like me. Okay. And so it's really important. Drafting is important, right? I have a complex story about someone who created a trust and how it all just didn't quite, well, it's not that it didn't quite work out. It just created some issues that we're sort of get into. So even if, you know, you're really smart and you're savvy and you think like, oh, well, you know, I could probably figure this out. It's not that big of a deal. I'll do my research and I'll get it all together. It might not end up exactly the way that you want because words do matter. So this story is about a woman called Barbara Young. She passed away and she was a widow, which really is not relevant. So, but her will included some language, right? It included a pour over language. So that means it's a pour over will. I've talked about this in earlier episodes. So if you want to get a deeper dive, you could check that out. But in any event, her will basically said if there was anything that wasn't in my trust, or if there's anything left in my estate, I want it to be poured into my trust, right? So whatever she had was now included in her trust. So one of the clauses that she had in her trust basically said that I want to leave $50,000 cash to my grandchildren. So I want my executor, who was one of her daughters, to give $50,000 to her grandchildren. So she passed away. Her daughter does not do this. And the grandchildren, which I don't even know how they knew that this was in the trust. Kudos to them for finding out. But the grandchildren ended up saying, hey, we want our money. Like, run me my money. You know, the time has come. And so, you know, Auntie was not doing that. And so they took her to court and said, listen, she's not doing her job. We want her removed as trustee and we want our money. And the court sort of, you know, agreed to look at this situation. Auntie's sort of defense was that, well, it says $50,000 cash, but there isn't $50,000 cash in their estate. There's just real estate in the estate. So I don't have to give you anything. And the court wasn't too happy with that. They were like, no, that is not the case. And they kind of gave, you know, a breakdown that I want to make sure that I share accurately. So there's 3 different types of ways that they look at these sort of gifts, right? They're like, there's a general legacy where you can say, I want to give my entire estate to my children or, you know, some more specific group of people, just generally, right? And then in that particular case, they would just, you know, divide everything. Then there's another way where it's a specific legacy. So it could be, the example I like to use is a crystal vase. Like, I want to give my crystal vase to my best friend. But if I pass away and there's no crystal vase in my estate, then my best friend gets nothing because there's no crystal vase. And that's called ademption. And that's what the aunt was trying to say is like, oh no, this is under ademption. There is no $50,000. They don't get anything. But the court said, no, this doesn't fall under a specific legacy. So they determined that it was the third kind, which is a demonstrative legacy, right? So if you say, I want to leave $50,000 from my Fidelity investment account to my, you know, grandkids, then they say, even if the Fidelity investment account is not there, you still have to make good on that because you can give that gift, right? It's possible to do it. It's not the case with the crystal vase. It's possible to do it. So they say that's actually how this falls. Even though she says $50,000 cash, you got to find a way to give this money. So she's going to essentially have to either sell the real estate or take out a loan or whatever it is to be able to give this gift to the grandchildren. So that's why I say it kind of matters the way that things are drafted, because we don't necessarily know what she actually wanted, right? Did she have $50,000 that she actually wanted to give to them, but she spent it before she died and therefore did not expect for that to be the case? We don't know because that's the way that it was written. So, after reviewing the specific language, the court said, no, we think that they should still get, the gift. They should still get this money. So long story short is, I know that everyone is not in the same financial situation. However, if you are in a situation where you have assets to be protected, then you need to really hire a professional to help you do so, because the devil is in the details. It's the little things that will get you caught up and will not, sort of end up in the way that you want it. This may not be like a major issue, but I'm sure what you have is important to you, and those who are going to benefit from it could be life-changing. So you want to make sure that you do things the right way. You don't want to take a shortcut with this. There's a lot of things you could DIY, but don't DIY your estate. So I hope this information was helpful to you, and I'll see you next time.